with just, live stream, got it. Okay, we're live streamed. All right, so Josh, we don't have a quorum with just you and I here, so I can't adapt the previous minutes, but I think it makes sense since we're moving on to the new topic, to at least you and I kind of start planning and maybe at least even kind of lay out a path so that we can hopefully move forward. And I don't know, I want to talk to, I think, John at our next chairs meeting, just about, our group is small. Unfortunately, we haven't seen Dawn in a while. I think Shonda can only come kind of towards the end. So I don't know if maybe it makes sense to look at so that we can actually have a full group discussion and get some stuff done, to see if a different time would work for people or something, just so that we can actually kind of keep moving along. And I get it, it's summer and people are on vacation and all of that.
I mean, we'd have a quorum if we had Gina, right?
Yeah, we would.
And Gina's always here unless she's on vacation. So
yeah. And I think that's, maybe that's just fine. And we keep plugging away, because I think our group does get quite a bit done, just probably because we're smaller.
Yeah. Less people to
so
disagree.
I don't want to necessarily lose that, but I also want to make sure we can still get stuff done. So, Josh, I also wanted, since you're here, I wanted to give you an update that apparently there was some confusion. I know very early on when we were talking about this, our group looked at the permanent bar, which felt like had been a directive from kind of the disqualification subcommittee. And we had looked at that pretty extensively and made we formalized recommendations for that. Apparently the disqualification subcommittee is now looking at it too. So I did try to highlight to them so that we don't have conflicting recommendations, but just give you a heads up, we could ultimately we may have some conflicting, I think, recommendations from that. I don't think it will be much. I think that group, I think even our group for the most part really just said the recommendations should be more in line with the federal requirements. And I think they're pretty close to that. But just giving you a heads up that, and I did have our presentation sent to the group of our recommendations back from May. So hopefully we can kind of bring that back in line.
I mean, that's fine. I thought we were helping them out because they had so much ground to cover, and it made sense for that topic to come to us, because we are also going to be looking at disqualifications from the perspective of the remedies part of it, not the existence of the bar.
Right.
Not the existence of a permanent disqualification period, but essentially the existence of the bar in terms of there being a remedy available.
Yeah.
So that's fine.
Yep. And I just wanted to give you a heads up. I had missed the DQ meeting prior to that. And so I guess I hadn't been aware that that had been put on the agenda, but just so you know. So, and I did clarify to the group, we are also, as part of this, going to be looking at that, the 260 or the 245C, the 0.24, that portion of the statute. So so now circling back, I did pull back up my notes from our February meetings where we were really still working to outline the topics that we were going to discuss. And so just to circle back, I think, and even our recommendations that were ultimately given back in February, where, kind of our three main issues were the permanency list, the preponderance of the evidence, and then the process. And that includes the remedies and things of that nature. And so I think for us, and then for that process, it was the turnaround, how easy it is to do, user-friendly, who gets a hearing, and then the availability of the bar, or, whether the bar applies. So I think we're really ready to move on to that third piece and sort of start formalizing that. And I think it would be helpful to formalize to determine if we need, for example, to put in a request to the data subcommittee if we need more data or something like that. So that's where I think you and I can still, even if it's just simply bullet points of that, but maybe define, kind of figure out what we need to make recommendations, if that makes sense.
Yeah. And can I add an issue to that list?
Yeah, of course.
Expungement.
Oh, okay.
And I'm thinking I'd like to, if we can, get a sense of what DHS's sort of internal policy on deciding how to respond to expungement requests are.
Okay.
If that has changed over time. And I think we should think about whether or not we want to recommend that the legislature have a clearer policy in terms of directing the agency on how, both the agency and also the courts, because it exists in this really weird place right now where the courts statutorily have the power to expunge DHS's records, but it only happens if DHS is given an opportunity to object at the hearing. So it's sort of like when you're doing an expungement case, then you've got this sort of whole extra party that you have to figure out, does it make sense to serve or not serve? And I think it is unclear to judges, sort of like, how are we expected to deal with this? And at times, at least early on after the expungement statute was granted or updated in 2014, DHS then was objecting really heavily and sort of seemed to take a position that any expungement was an infringement on its territory, its statutory duty. That in my anecdotal experience, it has not happened nearly as much, under the new commissioner, basically. But it's still sort of this like sort of black hole of what is DHS going to do. And I wonder if it just makes sense as a policy decision to just have expungements either worked for DHS or not work for DHS, or try to figure that out, or at least give the agency more guidance on when they should object or not object.
Yeah. I mean, I do think, especially because the expungements, and I can see the direct relationship, because expungements, if a record is expunged, then it's not used for the purposes of the disqualification. And so I think that I see that direct kind of correlation. So I think, well, I don't know if that's something we would put to Shonda, or if we could just ask Ms. Cassane since she's here. What's the appropriate? I don't want to step on anybody's toes.
Madam Chair, given how it's not a request for quantitative data, I think it'd be appropriate to just ask Ms. Cassane right now.
Okay.
Keep Chair Williamson in the loop. Okay. Which I can do.
All right. Ms. Cassane, did you, I know we weren't talking directly to you a few minutes ago, but did that make sense? Or, did you gather what we were talking about? I think essentially to understand how, because a expungement request would go to DHS and how they're responding, because that does have the interplay with the disqualification statute.
Yes, Madam Chair, I followed. It would be really helpful if I can if you can word it for me, just so I'm crystal clear when I make request to our legal department.
Yeah.
But I get what you're asking.
Yeah, Josh, I think you
make sure I'm not.
Yeah, I mean, I wonder if it's sort of it might just be helpful to frame it kind of broadly, could you guys give us an overview of how what the agency process is for responding to expungement petitions?
Okay.
And, are there guidelines for exercising discretion in those decisions? And if so, what are they? I think on the data side, it might be good to sort of pursue both both sort of just the overview explanation, but also maybe ask for, how many expungement petitions are they getting? How many are they objecting to? Like those types of things. What cases are they objecting to? Because we may find that there are there may be like more particular violent offenses or violent felony offenses that DHS is more likely to object to, and that's fine. And maybe we want to sort of think about that. But I'm also curious because I noticed anecdotally that occasionally there will be like permanent disqualifications that DHS doesn't object to. And I almost, we're waiting to see if there's an objection, and then it doesn't come, and it's almost like, man, I wonder if they are just looking at this and thinking, we would give a set aside if we could give a set aside, but we can't give a set aside. So we'll just, be quiet on, and I've seen that in particular for juvenile cases. Like we recently had a juvenile egg rob, which would have been a permanent disqualification that expungement was granted with silence from DHS. So it would be nice to, I guess, upgrade my understanding from the anecdotal, my little world to the agency, how the agency sees it.
And I think, Josh, that interplays, for example, when I had that former client that came and presented, who also technically had a permanent bar from when he was a juvenile, where ultimately we did get it expunged and there was no objection from the agency. So I think that even is the interplay between the juvenile records being used in disqualifications and things like, so I definitely see that interplay. And Ms. Kisane, if you'd like, I was taking notes as Josh was talking, so I can follow up when we're done in writing to be a little bit more formal if you'd like, so that then you can basically forward that along if you want.
Yes, Madam Chair, that would be particularly, the data points, I see you'd like an overview, probably. I can definitely easily have that discussion and coordinate with our legal team and coordinate that with Mr. Vogel. But the particular data questions, that would be really, so I make sure that I get the complete set of data points you'd like us to.
Yeah, so maybe what I'll do is when we're done, Josh, I'll type it up and I'll email it to you just to make sure if there's something else I should add, and then I can pass that along to Will and we'll get that to you.
Okay.
Great, thank you.
Yeah, then we're all clear and we're all on the same page.
Great.
Perfect. Okay, so I will definitely get that taken care of. Thank you, Ms. Kisane. I appreciate your responsiveness on that.
Thank you, Madam Chair.
Okay, so I think to me, I think for us, topics to look at, we'll put in that request. Sorry, I'm just taking some notes for myself here. So expungements, we do need to look closely at I think we look very closely at the 245C.24. That's the bars to the set aside. And Will, I'm trying to remember, I know that we have talked about it before, it has come up before. Have we ever done sort of a dive into the history on it? Because it looks like it wasn't sort of legislatively history-wise. It was created in 2003, and it's been updated a few times, even as recently as 2021. So have we done any sort of a dive as to why that was added or what's the reason for it or anything like that?
Madam Chair, not specifically with 0.24. That works focused on 0.15, the crimes or conduct list. I can say though broadly with 245C, so it was created in 2003. Essentially that was taking parts of 245A that had been growing and just grafting that text onto a new statute.
Okay.
And as I recall, the permanent from doing that history, the permanent bar component was created back in the 90s as 245A. But I'll follow up on that and get you a precise history.
Yeah, I think that would be very helpful, because I'm really curious And I mean, I gotta admit, I mean, I think 245C.24 is somewhat confusing in that, it starts going into foster care providers.
Oh, sorry, Madam Chair, you have actually reminded me that off the top of my head, I have gone through that history, and yeah, essentially those exceptions have kept getting added over time since the original 2003 version of the statute. So I'll run down my notes on what I've got there.
Yeah.
Can we go before we go further? Will, can I just ask a clarifying question about your summary of that history?
Mm-hmm.
Because it was my understanding that the permanent disqualification list, so the fact that there were some crimes that had permanent disqualifications, that dated back to the 90s. Yeah. But the removal of the ability to get a set aside was something that came in either the 03 or the 07 update. Is that different than what you thought?
It is, Mr. Esme, and I am just speaking off the top of my head here. I don't have those notes in front of me, so let me run that down quickly, actually.
And maybe, Will, I know we are constantly putting work on you, but maybe it would be helpful, I think, just if you could sort of put together kind of a recap for all of us on that. Now that we're back to this subdivision, because I think this is, these bars to the set aside. I mean, I don't think they're consistent with it. It doesn't make sense to me. And I'm trying to figure out what's the reason for it when we already have 245C.15. It feels very duplicative. And if anything, I don't know, I'm not seeing it. And I think we're going to have some major proposed revisions to this one based on other recommendations that we've already made, as well as recommendations that I think will be coming out of the disqualification subcommittee. So Josh, just a quick update. The disqualification subcommittee is really looking at bringing it more in line with the federal requirements. So you'd have the permanent bar and then essentially a 5-year bar, really for more of the felonies and maybe some gross misdemeanors. And so I think that's shaping up a little bit. And Josh, you can, Will, correct me if you disagree, but I think there's really a lot of talk about trying to kind of bring us more in line with the federal requirements and not our crazy structure that we have right now.
So they're going to just eliminate a lot of disqualifying offenses entirely?
That's
misdemeanors categorically?
I think there was that, except we're still going to have the problem of the domestic assault misdemeanors for.
Oh, okay. Yeah, I see it. Yeah. Ones that are required by the feds will still be there, but.
Yeah. So I think, so then that's really going to bring us in with the 245C.24. And then the other piece would be moving it. And well, I keep getting it messed up. So correct me. I think it was 5 years from the date of the offense. Because of all the delays and really recidivism rates, if somebody's going to reoffend, they're more likely to do it from the time of the offense rather than actually when they're discharged from probation.
That certainly seems to be the opinion of some members in the disqualification group, but others, for example, Mr. Page, have proposed a look back scheme that it draws on the child care statute.
Right. And that's where I know there's some different, I think there will ultimately be some sort of a compromise that will be shorter than discharge from sentence. Because I think there'll be a scheme of, for example, if somebody goes to prison, that will be one timeline versus if somebody doesn't go to prison, if I remember correctly. So, but it won't, I think the consensus will be, it won't be from a total release from probation, if that makes sense. So if somebody has a 15-year probation, we're not going to be waiting that. So I think that this 245C.24 becomes really important. So that's where I think it would be helpful to get more of that legislative history. And I think probably some major simplifications to it.
And can I flag something that I think is a question that would be helpful to answer in that research, Mr. Vogel, which is, can we get rid of the set aside bar while still being consistent with the federal requirements? Or do the federal requirements basically say, like, the state, can't have this remedy here because the federal requirements need, that permanent disqualification?
That's an excellent question, Mr. Esme, and I'll make a note of that. That may be an area for me to reach out to somebody with greater legal expertise, for example, in the revisor's office.
Yeah. Or I don't know, maybe Ben Johnson from the House Public Safety Committee might be willing to take a look at it.
And I think, and I'll just chime in here, and I think that would be interesting to look a little bit further into the Adam Walsh. Because I remember when we looked at that early on, it felt like Adam Walsh seemed to signify permanent is permanent, but I think that would be a curious interplay with that.
Well, and it's screwy too, because then we know that it's not permanent, right? Because we have a remedy through the expungement statute. But, I suppose, like, maybe one way of looking at the framework is Adam Walsh requires it to be permanent, but an expungement just removes it entirely. And, it's almost like Adam Walsh forces expungement to be the only remedy.
Mm-hmm.
But if that's the case, then I think that sort of puts further importance on clarifying what we want DHS's policy to be. Like, if our goal is essentially to not have there be a set aside bar of any type, right? That essentially, if you're able to show that you're rehabilitated, someone somewhere has to have the discretion to let you work.
Mm-hmm.
Then I think it might be really important to make sure that kind of everybody is following the legislature's direction on how to deal with expungements for those.
Yeah, I think that's a good question. And then, so I think another topic for us, so I think, Will, if you can work on that, and then obviously we'll look at that interplay. And then I think, just looking at my notes, we had said that we wanted to look at just really the appeal process itself, the user friendliness of it, the how quickly it can get turned around, who gets a hearing. So the actual appeal process itself was a topic for us. And I guess, I think that would be good to have a better kind of understanding and breakdown of that.
Do you think that starts with a data request?
Okay.
Like, turnaround time numbers?
So the data subcommittee actually did make a request for quantitative data on the timeliness of the process.
Okay.
Quite a few months ago, actually. And I followed up with the department, and they are working on it. I've not heard any specific timeline, but it is in there.
Perfect. And then, so that obviously we'll want that one. And then I think, does that one, I just have a note here of the part of the appeal process of who gets a hearing.
I think that might be something that I flagged.
Okay.
And it might just be referring to, at least from my perspective as a practitioner, it seems like really unclear to me. And it may be like clear in the statute. It's just that digging that far down in the statute is not easy. It seems that there's inconsistency in who gets a hearing in front of like what type of judge, depending on like what job it is that triggered the background study. And maybe we're fine with that. It seems messy and needlessly confusing to me. And so maybe just my like OCD is like, this should be tidied up in a way that like, has one remedy, but maybe there are reasons that I don't understand why some go to a DHS judge and some go to an ALJ and some don't seem to have any remedy.
And I think that's definitely a good question. I'm wondering who we could potentially, I mean, I don't think it's a long kind of information, but I'm wondering who could potentially give us some clarification. Would it be somebody from DHS, somebody from the AG's office? What do you think?
I don't know.
I don't know either. Well, okay, well.
I don't know if this will be helpful, but I did actually forward a copy of the PowerPoint that Katie Ryan presented on back in January, which.
Did she touch on that?
Yeah, it doesn't answer, well, I don't know if it's like specifically answering your question, but it does give background on the appeals process. Or the reconsideration process.
Okay.
Why don't we, before we ask someone outside of the group to do a bunch of work that we are not sure what we're asking for,
Right.
why don't we put that on my to-do list?
Okay.
To see if I can understand the issue a little bit better enough to at least formulate a request for an explanation.
That sounds good. Okay, I think that makes sense. And then let's see here, just looking.
Oh, there's one more tiny expungement issue.
Sure.
There's language in the statute right now. Well, there's language in the expungement statute, a specific provision that grants like a sort of a quick form expungement if the prosecutor agrees to it. And then the judge can just send out the order. And the purpose of that in the language specifically states that you can do that without a petition and without a hearing. And then that has sort of created confusion because the language in DHS statute says that they access expunged information notwithstanding the expungement unless they're given notice of the petition, and it specifically uses the word petition. So we've got this like mechanism to get an expungement without a petition that doesn't seem to contemplate that DHS would need a petition. And it would be really helpful to sort of bring those two statutes in line in a way that like still gives DHS notice and ability to object if they want to object, but sort of spells out how the law is supposed to work when the initial expungement is coming from the courts through this non-petition process.
Okay. And then just looking back, and maybe Will, if you could, just so that we all kind of recap it, back in February when we had made our initial recommendations or whatever we want to call them, that had I'm just looking at that had a pretty good list to sort of send out to people for this third portion of this. That maybe that can also kind of give us, just make sure we're touching on everything that we had talked about originally. I think much of what we're talking about is there. I just want to make sure we don't forget anything. Because I know some of this list includes requests from other people in the large group, that issues they've had and mentioned.
Yeah, Madam Chair. And in fact, off the top of my head, I think Ms. Williamson was interested in personnel issues essentially, which I don't know if that's something that you as chair want to touch on.
Yeah, so she keeps framing it in terms of accountability, right?
Mm-hmm.
And I mean, if she's interested in it, I think we should look at it, but I would like to think about what sort of the best way to frame that issue is. Because I'm not entirely sure if like what she wants are like sort of, we'll use the term personnel. So like, you know, like an employee discipline process for decisions that are wrong, or if what she's really interested in is more like a civil, you know, cause of action for being wrongfully denied, sort of like, you know, that sort of exists with conceal and carry permits. For example, if the sheriff's department wrongly denies your conceal and carry permit, you can go to court and get an order overturning it and costs, attorney's fees. So I don't know, maybe we need her to clarify with her. I'm not sure. What do you think, Cheryl?
I think what you framed is exactly what she's looking for. I had a note, just additional accountability for the purposes of identifying civil rights violations. And I know when that was brought up, I mean, one of the issues are going to be, of course, there's immunity, which is really, I think, much more built in there. Yeah, I mean, I think it's one I don't want to ignore it. It's important to her, but I also, I'm not sure how we can frame that it's going to make sense. And I think the bigger issue, I think if a lot of this other stuff can get cleaned up, I wonder if that in some respects solves some of the issues that maybe people who have had to go through the process feel like they've gone through.
Yeah, I mean, it's really hard for me to imagine a fact pattern where DHS is following their process and yet could come to an outcome that overcomes qualified immunity. I mean, it's always possible that there's some really bad actor that is not following the process, but then in my practice, I've come across decisions from DHS that I certainly disagreed with, but I've never come across a decision from DHS that made me think that like fraud or something was happening.
Right. Yeah. I think it's a tough one to overcome. And I think there's a difference between disagreeing with the outcome and actually having a wrongful action. So, but yeah, I mean, I think that's for sure on the list. And I think we just have to sort of think about that and what we want to do with that. But I know there was one, and I forget who brought it up, but like, for example, and I think we've already covered this some by our earlier recommendations where, for example, someone who's not having that direct care, maintenance, kitchen, things like that, don't have to have that same full background check. And then
Wait, isn't that something that the disqualification subcommittee is looking at, or no?
no.
Okay.
I think it's in line though with our earlier recommendations about how different, that it complies with the federal requirements. So like our recommendation that if it is required for the child care block grant or the Adam Walsh, it's one thing, but then if it's for, let's say, working with substance abuse disorders or that direct, family contact, that it follows more the 2008 recommendations, which are really just your really serious, murder, crim sex type felonies. To me, maybe that's just as simple if you're having that, although I know we'd looked at the statutory definitions, but if we're really maybe parsing that out so that the non-direct care maybe follows more of that 2008. I think that could be a simple, just sort through that. Yeah, I think that I just want to make sure we're sort of going through that list as we're kind of thinking about some of this. So I think if we could, I don't know, Will, could you keep us in the loop on that data request on the appeal process? Just so that we know. I'm thinking next time just so that we make sure we're kind of plugging away, Will, would you be able to, by our next meeting, be able to provide some of that history on 245C.24, and maybe we start tackling that one, because the expungements, we're going to be putting in a request to DHS. The appeal process, DHS is working on that request, but we don't know when exactly that will happen. But the bars to the set aside, I think, is one we're not waiting necessarily on, like DHS or some other group, that maybe we can start tackling that one, the 245C.24 next time.
Definitely, Madam Chair. I'll get something worked out.
Yeah, that would, if you have time, that would be great. And then that allows us to move on to that one. So I think that can give us a plan of attack to at least start working on some of this. And it does look like, okay, so our next one is scheduled for the 22nd. So we should be good.
Sounds good.
I think we've got at least a plan to start tackling some of this. I will send a follow-up email about the expungement requests. And then, yeah, Will, if you could just get out our recommendations from February to everybody to recap. And Josh, if you could just start working on who gets a hearing. And obviously, I guess if you're ready by next time and we can at least, cover that, or we can save it for when we actually get to that appeal process.
Okay.
Sound good?
Yep. Lucas, would you mind like a 5-minute phone call when we're done here?
Yeah, that's fine. You still have my cell? I can email it to you.
Okay.
I'm working from home, if you can't tell the casual dress today.
I'm working from the office in a t-shirt, so.
I'll email it to you. Yeah, perfect. Let's chat. Otherwise, I don't think there's anything else for today. I think we're